We are gathered in special session to hear one case, the Detroit News versus the Citizens Independent Redistricting Commission. Each side has 30 minutes. Mr. Wilder, as you well know, you can try and reserve some of that, but we hope you'll control that. And if you are ready, you may begin.
Thank you. Good morning, Chief Justice McCormick and Justices. My name is Curtis Wilder. I appear on behalf of the plaintiffs. I'd like to try to reserve 5 minutes for rebuttal. In adopting Article 4, Section 6 of the Michigan Constitution, the voters of Michigan acted radically to change the way that redistricting of legislative districts is done in Michigan. The voters sought full-blown transparency, flipping the process on its head to bring into light what had previously been done in secret. In this radical transformation of redistricting, the Constitution commands that anything the Commission does that involves developing, proposing, or adopting redistricting plans is the business of redistricting and must be done in open meetings. Any data or materials used by the Commission in support of that effort must also be published for review and possible comment by the public. In other words, the people told the Commission that it has to show its homework before it can receive a final grade. The Commission urges the court to allow this constitutionally mandated transparent process of map making to become secret whenever it or its lawyers determine the Commission needs legal advice in order to do its work. The Commission isn't shy about demanding that its attorneys should decide what Commission business is appropriate for public consumption. That's the standard of openness the Commission urged at page 39 of its brief. But this is not what the Constitution demands. How the court interprets the words that are key, business, and used will likely dictate the way in which redistricting is done in Michigan over the next century. Plaintiffs ask you to reject the Commission's narrow reading of those words that would allow legal counsel to become the gatekeeper in determining what communications are appropriate for public consumption. Instead, plaintiffs ask this court, consistent with the common understanding of the people who wanted redistricting to be done in the light of day and not in secret, to direct that the video or audio of the closed session held on October 27 and memos relating to the work of the Commission in drawing redistricting maps should be immediately posted for public review and consideration. Plaintiffs do not assert that the Commission can never have privileged communications with its lawyers. Whenever litigation is existing or at any time after the final maps have been adopted and litigation is imminent, invocation of the attorney-client privilege or work product doctrine would be consistent with the openness required by the Redistricting Amendment. But until then, all of the work of the Commission must be done in the view of the public, subject to public scrutiny, including the review and discussion of information provided by the Commission's lawyers in the aid of its work. To allow otherwise would be repugnant to the expressed will of the people. Chief Justice, if court has questions, I would yield at this time.
I bet they do. Thank you very much. I'm going to start with Justice Zara.
Good morning.
Morning.
Counsel, I got up early yesterday because I couldn't wait to see the brief in response to the complaint. I anticipated what the response might be, and eventually at page 19 of the brief, it actually says the memoranda at issue are not data and supporting materials used to develop the redistricting plans. In other words, the plans that were actually developed were developed without use of this material. I understand you're relying on Article 4, Section 6, subsection 9, but when I read that, what's unreasonable about a proposition that what must be produced is things that were actually used to develop the plans that are presented to the public?
Well, how the Commission understands its obligations under federal law is critical to meaningful public participation. And as subsection 13 provides, those criteria must follow the Voting Rights Act as well as other federal law. And the idea that that is not used in the drafting and adopting of the maps is really preposterous. It is clearly used, and it must be used in order for the work of the Commission to be done appropriately. That's why this is part of the business of the commission.
You described what needs to be produced as show their homework before getting a grade. I think I wrote down your exact words. They must produce everything to support that effort. Now, taking us out of the realm of the two memoranda produced by council that you're specifically asking for, is it your position that any document, anything that was presented or that a commissioner touched and looked at in the process of developing a plan must be produced to the public?
If you look at subsection 8, the public has the opportunity to submit proposed plans and supporting materials. And I would say you would read those sections in tandem. The question is, what is the commission actually relying upon in the development of its plan? Clearly, they relied upon these two memos. They may have relied upon other supporting materials, but all of those materials inform the actual adoption, drafting, development of all the proposed maps. And those materials ought to be published. And if you go to the commission's website, you will see many of those things that have been submitted and links to links, which include a lot of data, some of which isn't very interesting perhaps, but clearly was used by that person who submitted the proposed map. And that's what's required here with respect to the commission and the commissioners.
Okay, I'm not sure you answered my question. Everything that they looked at in any way has to be produced, yes or no?
Everything that informed their development. If they discarded something, oh, this is not useful, no, they would not have to publish that. But if they use something that is actually informing the development of the maps that they would sign on to, then yes, that would have to be published.
How is that line drawn, and who draws it?
Well, the court would draw
whether something is not useful. I might read something and say, well, that's really not useful to my effort. You say anything that informs. How is that line to be drawn, and who draws it?
Well, I think the court would draw it and say that anything that the commission is using to inform its maps, that has to be part of the supporting materials. It's supporting. The question is, what's supporting? If it's not supporting, then it does not have to be published.
All right, thank you. I'll pass it on to my colleagues. I'm sure there are other questions.
Justice Viviano.
I have no questions at this time. Thank you, Counsel.
Justice Bernstein.
Good morning, Counsel. And I have to say, it's wonderful to see you. And I want to wish you a very Merry Christmas. I just want to ask kind of the way I always kind of approach things is, as you know, since we've worked together, I always like to look at things in a very common sense approach. Keep it simple, but just apply common sense, because that usually kind of gets you to where you need to go. And I guess the question I have for you is, if you look at the names of the documents that are in question, I mean, if I'm not mistaken, that one of the names is the history of discrimination in Michigan and its effect on voting. And then also the second one, the Voting Rights Act. It just seems to me that, ultimately, and I'm just going to let you expound upon it, that from a commonsensical perspective, wouldn't a person just naturally assume that those documents are relevant in creating the maps that are basically the entire essence of why we're here?
That's exactly our point, Justice Bernstein. You can't draw the maps in a way that complies with the Voting Rights Act without understanding the history of how it hasn't been in compliance. You have to understand the history of discrimination. You have to understand the background and nature of what you're dealing with when you're applying the criteria that are in subsection 13 in order to make sure that the maps, as some of the commissioners have said, are done right the first time. They want to comply with the law. The only way you can comply with the law is to understand the historical background. And that's why it's critical that the public also be able to participate in understanding what the commissioners see as the history, so that the public can also comment on that critical foundational information with which the commissioners will decide ultimately to adopt a map.
And council, would it be fair to say that a lack of transparency will ultimately go to the credibility of the commission's work? Because when things are done without shining a light, it always leads to questions.
In fact, the commission agrees that transparency is the touchstone of this redistricting amendment. And this is why the amendment requires that all business of the commission be done in open meetings. It's so that there isn't suspicion that things are being done in secret. And so I would agree, Justice Bernstein, that releasing all of the data and supporting materials is critical to having public confidence in what the commission has done in proposing maps.
Council, thank you very much.
Thank you, Your Honor.
Justice Clement.
Good morning. Just one question. I'm thinking through the attorney-client privilege issue. Tell me, if these documents are not covered by attorney-client privilege, what type of interaction between the legal counsel and the commission would you consider to be covered by attorney-client privilege?
Well, for example, I think it is document number 3 does actually mention pending litigation, discussing legal strategies. That would be the kind of thing that is clearly protected by attorney-client privilege. It's involving in litigation. Everything else that involves the drafting, the adopting, the proposing of maps, that is the business of the commission. And the Constitution makes a clear choice that all of that business must be produced at open meetings.
So the litigation has to be has to exist and be real at the time. It can't be a memo about, let's say, the Voting Rights Act and what litigation could come based on decisions that the commission makes.
That's correct, Justice Clement. As we mentioned in People versus Whitney, the attorney-client privilege cannot swallow whole the requirement for transparency. There has to be something imminent, something specific, and not just this possible idea that there could be litigation. If that were the test, and the idea that there will be groups that will challenge the maps, no matter what, that would swallow whole the transparency that's required by the amendment.
Okay, thank you.
Thank you.
Justice Kavanaugh.
Thank you. I just have a couple questions. I'm hoping you can sort of help me figure out sort of the bounds of what you're saying about the attorney-client privilege. So I understand you're saying that your client's not taking the position that the commission doesn't have or has no right to confidential communications with its attorney. You're not taking that position. And I assume you're saying, and tell me if I'm wrong, are you taking that position because it necessarily is inferred from the fact that the Constitution provides the commission with the right to legal representation?
Well, the Constitution provides the commission with the opportunity to have standing to pursue litigation and also to defend litigation. That is an express recognition that there will be litigation and that the attorney-client privilege would attach to that. But the Constitution also recognizes that it would be necessary for the functions and activities of the commission to retain legal counsel and any other activity necessary to conduct its business. So there is a dual function for the lawyers. Part of the function is to defend it or to prosecute it in litigation, prosecute litigation on its behalf. The other function is to assist it in the business of the commission, which must be done in open meetings.
Okay, so following up on that, if excuse me for a minute, if following up on that, if we're saying, we're inferring this sort of dual role or bifurcated way of looking at the right to counsel and how that informs privilege. And we're going to assume that because it's allowing the commission or anticipates that they have to defend or litigation of these maps, that comes with the understanding of attorney-client privilege with respect to that, but not with respect to this other role that you reference of doing the business of the commission. Why do we infer that from when there aren't words that say that, right? I mean, I look at section 8 that says, you know, the commission shall receive written submissions and any supporting materials, including underlying data from any member of the public, and specifically says these written submissions are public records. If they're saying you have a right to legal representation, but the communications with the commission with respect to doing this one particular role is not subject to privilege, like how, I mean, if the Constitution doesn't explicitly abrogate the common law right to attorney-client privilege, how are we supposed to infer it? But we can infer it with respect to litigation, but we can't infer it with respect to the other work of the commission.
I go back to subsection 5 and let me read it in whole or the relevant sections of it. The legislature shall appropriate funds to enable the commission to carry out its functions, which activities include retaining legal counsel and any other activity necessary for the commission to conduct its business. The Constitution expressly states that having lawyers is an activity necessary for the commission to conduct its business. And the Constitution also says that the business of the commission will be conducted in open meetings. There's no inference there. That's a direct statement.
Okay, but the Constitution doesn't say that you can't, I mean, it doesn't specifically say that with respect to defending litigation, the commission does retain attorney-client privilege.
That is
we're just saying, well, of course it does, because how can you have an attorney and not have the right to, confidential communications? Like, of course it does in litigation. And I think that's the provision that you're taking. Like, for example, I don't think that you would take the position that, an email from Mr. Fink to the commission saying, look, we're filing our brief on Monday. Here's the position that we're taking in this brief. You wouldn't take the position that email, that communication between the commission and Mr. Fink is not subject to privilege. You think, I mean, of course it is, right?
I would say that the development and the proposal and adoption of maps is the business of the commission. Defending the maps is not the business of the commission as defined by the Constitution. That's your clear demarcation. They don't
have privilege with respect to communications with their counsel if it relates to defending the maps, even if in litigation, or there's a carve out if there's an actual suit pending.
I'm sorry, Justice Kavanaugh. What I thought I said and what I mean to say is that if the commission is defending the maps that it has adopted, that is not the business of the commission as defined by the Constitution. Anything up to that point, the development, the adoption of the maps is the business of the commission. That's the defining line. That's the bright line that can be drawn as to where the attorney-client privilege attaches and where it does not exist.
Can the commission do something that the Constitution doesn't give them authority to do? If you say that it's not their business to defend the maps, do they have any authority to even defend the maps then?
They do have authority to defend the maps, but it's not the business of the commission as defined by the Constitution.
And that is in subsection 5.
Subsection 5, yes, is
okay.
Part of that. There's subsection 8, subsection 9. There are a lot of subsections that define the business of the commission.
The business of the commission. Okay, thank you very much.
Thank you, Justice Kavanaugh.
Justice Welch.
Thank you. Thank you, Mr. Wilder, today for putting forth these arguments. I want to just follow up on Justice Kavanaugh's questions. First, circling back, so I think we have agreement that hypothetically, if there's a lawsuit on January 2nd, that the maps are somehow don't meet requirements of the law, those communications with their attorneys would be privileged, correct?
Yes, Justice Welch.
Okay, so today's litigation, it's not about the maps. I mean, not defending the maps after they're drawn and all. So I am curious, what's your position today? Are you entitled, would you claim you're entitled to all of Mr. Fink's communications with the commission in preparation for today?
I would not. It's litigation. In
Okay.
litigation, clearly, the attorney-client privilege attaches.
Okay, so once like the lawsuit is filed, what triggers it?
The lawsuit and the fact that it's imminent. If you get a phone call and say,
Vocal
we're going
about
to be suing you, or an email.
There were lots of groups that were saying these documents should be public. So the press was pretty clear. They were pretty open about expecting this stuff to be out in the open, and may have even mentioned a lawsuit. At that point, would the privilege attach?
I would say that litigation would be imminent and specific. The imminency would be, we want these documents. We're going to take the steps to get them if you don't release them. And they would be specific. It would be about the documents, specifically about those documents.
Okay, so then, and I know this is the line drawing that's difficult. So, typically I read the privilege as certainly covering threatened litigation. What do we do about the fact that when this proposal was drafted, it was very well known that lawsuits would result. In the end, I mean, every commission in the country got sued after their maps went into place. So that was a pretty well-known fact. And there's sites and media sites and stuff that litigation was going to happen. This commission knew it was going to have litigation in the end. Are they allowed to prepare for that eventual litigation with their attorney?
The Constitution says that all the business will be done in open meetings. And that was the policy decision that the voters made. They could have said, except for specific discussions about pending or potential litigation with counsel. That was not made. And the fact that there could be a lawsuit at some point in time over some of the maps, if that is enough to attach privilege, that would swallow transparency whole, where you can never draw the line.
Well, sure. If someone could go in and, I mean, obviously we're talking here 70 minutes out of hundreds of hours. So,
Correct.
I understand the argument. I want to circle back. You cited section 5, subsection 5, for sort of the budgeting of the commission, if you will. Section 4 is the language, and Justice Kavanaugh was talking about this. I'm reading directly. The commission shall have procurement and contracting authority and may hire staff and consultants for the purposes of this section, including legal representation. I'm really interested that the drafters actually used the word legal representation. They didn't even just say attorney. They said representation. Does that matter? And I guess I'm wondering, what is legal representation?
The legal representation would be when they get sued.
But
There's another provision that says that they can hire lawyers to help them with the activities of the business. They're two separate sections.
okay, so, but Mr. Wilder, so today, I'm guessing there are hundreds of clients that are going to call your law firm today under the guise of legal representation. Do those clients have an expectation of privacy for those conversations?
If they're asking me about specific litigation, they would have an expectation of privacy. But that's, again, the commission or the Constitution made a distinct choice that if it involves business, it's in the public. And that is something that the Constitution requires and it commands. And there is no exception for that, only if there is litigation in which the attorney-client privilege would attach.
What about the notion that it does use the term that, meetings should be in the open, but, our state has understood what open meetings mean for a really long time. City commissions meet in open, school boards meet in open, the Senate, committees, every public entity possible meets in the open. But the people who participate in that and the public understand that does mean that there is a right to privilege. Why is this group different?
Because the Constitution said all of the business shall be in open meetings. And the Constitution describes business. And it describes that attorneys would be assisting the commission in its business. That's why. It's because the Constitution specifically sought transparency as opposed to allowing secrecy.
Okay, and my final question, and I actually don't genuinely know the answer to this. Do you know of any entity, person, nonprofit, public sector entity that if they have counsel, they are not entitled to the privilege anywhere? We know the commissions in the rest of the country all have a right to the attorney-client privilege. I've never heard of someone not having the privilege.
My understanding is those other commissions that have attorney-client privilege expressly wrote that in either the Constitution or in their statutes. There was no express declaration of attorney-client privilege. It's specified with respect to litigation, and it's specified also that when it involves the business, that shall be done in the open. So, this is a radical transformation. What used to be done in secret, the public wanted done in the open.
Okay, so the public, your position is the public intended to do something that literally no other entity in the country is subject to.
That's correct.
Okay, thank you.
You're welcome. Thank you, Justice Welch.
I might be, my questions might start to feel boring, and I apologize, but I also am trying to understand that, I appreciate that. I appreciate that your view is there is privilege for at least some of the work that an attorney would do for the commission, and trying to figure out how to draw the lines around it feels very tricky, and a job I wish the Constitution had given to someone besides us. I'll just put it that way. But here we are. I appreciate the defending litigation feels like the easy part of this, at least from your position, counsel. And then I think you also said if litigation is imminent and specific, you wouldn't disagree that there is a right to privilege. But this second function, the assisting the commission in its doing its business, is where your view is there is no privilege. And obviously the Constitution doesn't specifically say, your lawyer can help you with that business, but we don't mean lawyer in the traditional sense, because lawyer in the traditional sense means a lawyer that you can get confidential information from and you can have confidential conversations with. So we have to infer that the language meant to abrogate that part, that, the oldest privilege in the law, because of the other language that the business has to be done in the public. That's how we get there. Is that your understanding?
Correct, Chief Justice McCormack. The Constitution is clear. When it's business of the commission, it's an open. It's in the public.
So what's the value of having a lawyer then? I mean, why not just like sort of a smart helper? Why do we call it a lawyer? I mean, it feels to me like the value of a lawyer is, well, hopefully there's other values of lawyers, but I don't mean to cast too much shade on lawyers, but I feel like the most important value of a lawyer is it's somebody with whom you have a confidential relationship, right? Isn't that what we learn in the first week of law school? Like, what is the value of a lawyer if you don't have a confidential relationship?
There's a public participation function here as well. To have the legal criteria for the Voting Rights Act explained at a public meeting also helps to inform the public about how well the commission is doing its work. And that's what the Constitution sought to have. It has a lot of public participation. There has to be technology used. so that people can participate remotely. That is a central and core feature of this Constitution, that there would be public involvement at every stage, and that includes meeting the criteria under subsection 13.
So I agree with all of that, but I'm not sure it answers my question. What value is a lawyer to you in assisting with the business of the commission? If you're a commissioner, or you're the commission, what value do you get if a lawyer gets to assist you in your business if you can't have any confidential communications with your lawyer? Why do you need a lawyer? Why isn't it just it feels to me like if that's the line, then I don't think you need a lawyer. I would just get a smart historian, or I don't know, political scientist. I would get a political scientist, I think.
Excuse me, Chief Justice.
No.
I think you would want a lawyer to help interpret the law to tell you what is appropriate and what is not appropriate under the law in the developing of your maps. And there's nothing that says that advice can't be given in public. The cases are certainly public, and the lawyer can interpret that and provide that in public. There's nothing that says that advice has to be any less valuable to the commission, and it certainly is valuable to the public to understand how the commission is and whether the commission is doing its work.
That's a good point. Point well taken. I appreciate that. That's helpful. So that would be a reason why a lawyer would be different than a political scientist. A lawyer knows the law. They can actually tell the commission in front of the public, here's how you could, here's where this could get into trouble, and here's how it might not, you can do what you want with that. You also said in response to Justice Zara that if the information did not turn out to be, I think what you said was helpful, not useful in the business of the commission, right? Let's say Mr. Fink gives the commissioners some information about what Mr. Fink thinks is important, and the commissioners are like, well, that was dumb. I don't know why we hired Fink. That's not useful to us at all. Then it does not have to be turned over. Is that what I heard you to say?
I guess the question is, what's supporting? If the information leads you to the conclusion that this is the appropriate way that we should do this, and not that way, then it would be something that should be released to the public.
So that would be quite a subjective inquiry, and we'd leave it to plaintiffs' counsel to sort of figure out, and we'd have to trust them. And if there was a reason not to trust them, you bring it to a court, and a court sorts that out, like we do in other cases where there's a conflict between the privilege and some disclosure requirement, right? This happens in discovery. It happens in it's something courts do, right? They sort this out. Okay, understood. So the litigation specific privilege, I heard you to say would apply to defending maps. It would apply to this litigation rate that's happening right now. I assume it applied then. There was litigation about the commission in August and September. I don't remember when we resolved that one. I know we had some questions before. So I assume there was privilege around that litigation for that period, according to you and your clients. Is that fair to say?
That's correct, Chief Justice McCormick.
Okay. You were extremely helpful with my questions. I know we've used up all your time, but I'm going to see if anybody else has follow-up questions, because this is our only case this morning, and I don't want anyone not to have questions answered, if it's okay with you.
It's perfectly fine with me, Chief Justice.
Thank you. Any additional questions for Mr. Wilder? We may come at you again after Mr. Fink's turn, so please don't leave. Please stick with us.
I'll be here.
Okay. Mr. Fink.
Thank you, Your Honor. May it please the court, David Fink, appearing on behalf of the commission. First, I want to say to the Chief Justice that I do not take offense at her suggestion that my advice was dumb. In November of 2018, the voters of the state of Michigan took the power to draw legislative district lines away from a partisan process and gave it to the people. They created an independent citizens redistricting commission. The voters amended the Constitution with very specific language. They knew that the commission's work would be challenged in court. As Justice Welch has pointed out, every commission's work has been challenged in court, and there are multiple references to those challenges right in the amendment. They knew the commission would need lawyers to provide legal advice and to defend the work. So the Redistricting Amendment explicitly provides that the commission would have, as we heard earlier today, legal representation. It explicitly provides that the commission would be empowered to, quote, defend any action regarding an adopted plan. And it also provides the legislature has to fund that defense properly. It even provides that the commissioner's terms cannot expire, quote, before any judicial review of the redistricting plan is complete. How much more could they have anticipated litigation? And by the way, as some of you may have noted, we couldn't help but put in the footnote that the Detroit News, one of the parties on the other side, explicitly in their editorial opposing the initiative, explicitly said that there would be litigation. Now, in the voters' common understanding, could they possibly have intended both that the commission would have effective legal representation and that the commission could never communicate with its lawyers in confidence? By the way, today we hear this exception, except in litigation, which wasn't as clear in their briefing, but nonetheless, until litigation, we cannot consult, the lawyers cannot consult in confidence with the commission. Is that a common understanding? And in the end, all of this comes back to common understanding. What did the voters intend when they voted for this? Could their common understanding have been that they intended to create a strong, independent commission? And I don't think anybody can doubt that's what they intended. But they intended to hamstring that commission by preventing it from having effective legal representation. Now, today and in the briefs, the plaintiffs argue that the requirement that the commission conduct all of its business at open meetings, that language, somehow by silent implication abrogates the common law attorney-client privilege. And today we learn that by silent implication, this amendment is supposed to have abrogated the attorney-client privilege only if we're not in certain types of lawsuits. But otherwise, the privilege is abrogated. Well, we all know that abrogation has to be explicit and it has to be clear. There needs to be a clear statement, and there is no such clear statement. Instead, the actual clear statements in the constitutional amendment empower an independent commission to do the hard work but necessary work of democracy, to draw districts for the people's representatives, and to do so free from partisan influence and without interference from the legislature. It's clear that defending the commission's work requires some strong legal representation, and that legal representation can only be effective with unfettered attorney-client communications. Now, I have a lot of other comments on the questions we've heard already, but I think I should be quiet and wait to hear the specific questions that the justices have for us.
I did it myself. I didn't unmute myself.
Finally it happened.
Yeah, they're all happy to see me do that. It's like, Shonda. Justice Zara.
Thanks, Mr. Fink. I understand what you're saying, but the Constitution expressly says that subsection 9, any data and supporting materials used to develop the plans would be made available. You think the public didn't expect that when it says any supporting materials be made available as it relates to the development of plans, that's any with an exception. If a lawyer happened to say, here's how you should do it, we're not going to let you know about that. And you know, the distinction of litigation, I don't see it as a distinction of litigation. There's privilege, non-litigation, there's not. If the legal advice is given as it relates to the development of the plan, It's going to be open to the public. What you say is not going to be just to the commissioners, but to anyone who's interested in learning how these plans were developed. When it comes to defending the plan, that's a different story, because defending the plan isn't material related to the development of the plan. The plan's already developed. There I see a clear attorney-client privilege. But as it relates to documents used to develop this plan, I think the people expected an open process, and that any material, including material that comes from the lawyers, would be made available so that we understand what the law is and how the commission reached this result. What's wrong with that interpretation?
Well, first of all, it disagrees with my view. Your Honor, I do actually appreciate the interpretation, because the language of Section 9, in Justice Zara, you're right on it. The language of Section 9 says that we are to publish any data and supporting materials used to develop the plans. So if something was actually used to develop the plans that were first released under Section 9, and by the way, those are plans that were released to the public on October 11th. The two memos that we're talking about, both were provided after October 11th, so they couldn't possibly have been used to develop the plans. But if there was a memo, if there had been a memo that was actually used to develop the plan, I'm not sure exactly how that would have been. I can tell you that it's the commission's judgment to decide what was used to develop the plans. And in that regard, it's astounding to me how open this process has been. They not only conducted 136 public meetings, and at every one of those public meetings took public comment, but not only did they do that, but as has been noted, under Section 8, every single public comment, without exception, every single public comment is in the record. Every communication, every discussion, every back and forth, no matter how mundane. My God, my response, my firm's response to the RFP to be litigation counsel, because they did anticipate litigation, our response is in the public record. Everything is in the public. It's the most fulsome public record I've ever seen of anything. The only thing that's not there are attorney-client communications, and they've been identified. Now, again, these two items can't possibly be the items that violate that section. We got to be clear about that. But beyond that, if there were a memo that was used by the commissioners to develop the plan, it would be the responsibility of the commissioners to come forth with that the commission, I should say, to make that information public if it was necessary, if it was used. But as we talk about developing the plan, let's be clear what these documents are. This is the actual data, and there's some guidance on what we're really talking about when you look to Section 15, which talks about releasing the information, including the published materials, including the reports, and it says that the published materials shall be such that an independent person is able to replicate the conclusion without any modification of any of the published materials. So we have some idea what they're talking about. They're not saying, and let's be clear about this, counsel had earlier referred to what understanding, if it informed the understanding of the commissioner, it must be in the record. No, if that were the case, every time someone picks up and reads the Detroit News, the Detroit Free Press, or listens to something on the radio or a podcast or goes to social media, all of that information affects our understanding of the world. And that understanding and the understanding of what would be right for redistricting. So the commissioners could put, it's almost endless, it is endless what they could include, but absolutely. Justice Zara, you do get to the point, which is what was used to develop the plans. So it's all the actual data, all the voting information, all of the census information, all of the map drawing information. There's a lot of complex information that was used to develop the plans, and that should be included. But some attorney-client communications, they're attorney-client communications. It's that simple.
Thank you.
Justice Viviano. Oh, sorry, Justice Zara. More questions?
No.
Okay, Justice Viviano.
Thank you. Mr. Fink, as I understand it, your position is that, and I think the law supports this, that your claim of privilege is based on the common law, is that right?
That's correct, Your Honor.
Unless it's in conflict with the terms of this constitutional provision, right?
Unless it's repugnant to the constitutional provision. I say that only because it's not just that it'd be a little bit different. It has to be directly inconsistent and literally repugnant. But yes, I agree.
The Chief Justice said that the attorney-client privilege is the oldest privilege in the law. But according to at least one commentator, prior to 1963, only 2 courts had held that communications between government employees and government attorneys could be protected by the attorney-client privilege. So if that commentator is right, it turns out that this privilege, government attorney-client privilege claims, may not be so old, and in fact may be a product of the modern sort of litigious society that we live in. But be that as it may, my question to you is, has our court ever recognized the attorney-client privilege claimed by a government client? Has this court ever recognized that? In other words, what is the common law in Michigan as it pertains to claims of attorney-client privilege by government clients?
I am not certain. I do recall seeing cases regarding the scope of communications between that government lawyers have with their counsel. And I don't know if this is a trick question. I don't think it is. I've often.
Well, let me just jump in and save you then. I couldn't find any cases from our court. Doesn't mean they're not out there. This case came to us on a pretty fast track, but there are some Court of Appeals cases that sort of assume that the privilege, the private sector privilege exists, but never really address the point head on. But let me move forward. Your opposing counsel concedes, I think wisely, that there's some room for your claim of privilege as it relates to litigation. There's been some discussion of whether or how difficult it would be to draw that line. But that's a line that we have to draw. This is sort of goes off my point a bit, but that's a line we have to draw all the time, isn't it? When there's claims of work product privilege in anticipation of litigation, isn't that a line that our trial courts draw almost every day when those claims are made?
Yes.
Yeah. So so anyways, let me go back to the. And if I may, I
do remember the case that we had looked at. In fact, we cited it, but you're correct. It was a Court of Appeals case, McCartney, which related to disclosure of letters to the governor. So I'm sorry, I did want to.
Yeah, no, I appreciate that. And there's some other cases I think that also arise in the context of either the Open Meetings Act or the Freedom of Information Act, or a combination of the two. But going back to the scope of the common law privilege that you're claiming, which is on behalf of a government client, this commission. Again, there are commentators who argue that the privilege should not be extended really at all to government lawyers, because the ultimate client might be the public and not this public body. What's your response to that?
My response to that is that that we need to look to the common understanding of the people when they voted here. And the Open Meetings Act was widely understood. I'm not saying that the Open Meetings Act was explicitly incorporated here, but that was an understanding of what an open meeting is. In fact, the language of the Open Meetings Act in some respects is broader than the language here, because the Open Meetings Act doesn't just limit itself to the business conducted. It says the commission, the Open Meetings Act, well, specifically says that all meetings of a public body must be open to the public. Okay. Despite that language, we all know that under the Open Meetings Act, you have two important exceptions. One is the exception for any litigation that's ongoing, and that's explicit in the Open Meetings Act. But two is the reference to other statutes, which brings you to FOIA, which provides that Freedom of Information Act, which provides that there's an attorney-client privilege on documents that are exchanged. And as a result, any discussion of documents is excluded from the openness required by the Open Meetings Act. The closed meetings can occur. The reason I'm saying this is I think it's directly pertinent to the question you're asking. That is, in every one of those instances, you're talking about public representation of some public client. And as we all know, without exception, every single public body in the state of Michigan has the power to and exercises the power to conduct closed sessions to obtain attorney-client information on a regular basis every day of the week. And that comes back again, the common understanding. What did the voters mean when they said what they said, when they did what they did? And if what they intended to do was for the first time ever create a partial abrogation of a privilege, not even a complete abrogation, a partial abrogation of privilege for some limited purposes, wouldn't we expect a clear statement? And there's none whatsoever.
Is your client required to follow the Open Meetings Act?
No, the client is authorized to determine its own procedures. And as such, the client determined that it would be appropriate to essentially, if you will, appropriate the language of the Open Meetings Act for clearly understood standards, procedures, and guidance, which has worked extremely well. And again, the concepts of the Open Meetings Act, in fact, I don't often cite this, but the Mackinac Center in their commentary before the voters voted in October of 2018, the Mackinac Center explicitly said that this reference to open meetings meant that the Open Meetings Act would apply. Now, literally, no. Literally, the Open Meetings Act.
I think what I hear you saying, or at least it sounds to me like you're saying, the Open Meetings Act provides more protection than the common law. Is that what you're saying?
No,
your client wants to shelter under the Open Meetings Act.
The Open Meetings Act provides a little less, frankly. The Open Meetings Act provides a little less protection than the common law privilege, but that's what's been adopted by the commission.
Your client can't arrogate to itself more protection, a greater privilege than the one that existed at common law, can it?
No, and they haven't attempted to. They cannot, and they would not.
A number of courts have looked, I think, at this situation where the government claims this privilege and have tried to balance these concerns. The restatement talks about it, I think, as well. And they oftentimes come down sort of where the plaintiff is advocating here, where there's more of a privilege as it relates to litigation, but less as it relates to the business of a public body. Why should we not narrowly construe the common law attorney-client privilege in the context of government clients in that way, taking into account, as you said, and I think everyone agrees, that transparency and disclosure of information is one of the main sort of motivating forces behind this amendment.
Well, first of all, this would be a massive change in the way that businesses that the business of government is handled all across the state of Michigan. Government attorneys all across the state of Michigan have the privilege.
Well, let me jump in because I don't quite understand your comment. All those other public bodies operate under the Open Meetings Act. in the Freedom of Information Act.
Correct.
And so why would it, they could shelter under those provisions, which could either abrogate the common law or grant more protection than the common law privilege to government bodies in Michigan. So why would us narrowly construing the privilege here affect those other public bodies?
I'm sorry, I didn't mean to suggest that this was going to change the law for the other bodies. I was simply suggesting that that would make this unique. And by making it unique, we're stepping away from the common understanding of the voters. The voters knew what they were doing.
Well, let me jump in. It is unique, right? Because it's not subject to the statute that governs everybody else. And instead it's subject to a unique constitutional provision. So it is unique to begin with, is it not?
It is unique as to redistricting, but is to be interpreted in the way that the common understanding would be. What would the voter think when they're voting? Would they really think that we were creating an entirely different kind of approach? Justice Viviano, you asked me a broader question about the government, the right of government attorneys, of attorneys to get consultation from government. And I can't help but note something that was referenced in our brief from the Sixth Circuit Court of Appeals. And obviously this isn't a federal case we're dealing with, but I think it gives some good guidance when the court said upholding the privilege furthers a culture in which consultation with government lawyers is accepted as normal, desirable, and even indispensable part of conducting public business. Abrogating the privilege undermines that culture and impairs the public interest. I'm not saying that it couldn't have been done. I'm saying it didn't happen. I'm not saying that they couldn't have said there could be a constitutional amendment to eliminate attorney-client privilege and to hamstring every public entity in the state, or just a select number of them. But it would have to be explicit. It would have to be plain, understandable, certain language. And that didn't occur.
Your position, and I just leave you with this last question. Aren't you assuming the existence of a robust attorney-client privilege at common law for government clients? That's your starting point when you say then they would have to be explicit in the Constitution to abrogate it? What I'm asking you is, even your citation to the Sixth Circuit case shows that whether or not such a privilege should be recognized is something that courts still are thinking about, right? So why should we just accept as a fait accompli that the privilege you're claiming is coextensive with the oldest privilege known to man?
Well, Justice Viviano, I would say this because I'm not as old as man. I would say instead that, as you've indicated, by 1963, at least, when the Constitution was adopted, we did have an attorney-client privilege for public representation. I've only practiced since 1977.
Not based on any case from our court that you or I have been able to identify, right?
No, but I can tell you that since 1977, I've practiced law, and we have to look at the context of what we were in 2018, and certainly all across the state, without exception, all public bodies, all of them believed and understood that they had an attorney-client privilege and that it wasn't narrower than the public attorney-client privilege. And that just, I know I keep saying it, but that's the common understanding. And that's what drives what the amendment means.
I think you make a fair point. I want to yield to my colleagues. I've taken up more time than I should have. But all the way up to your last point, which is I'm not sure. I agree with you. That's the common assumption of lawyers. I'm not sure was the common understanding of the people. That's sort of the question we have to answer. But I'll yield to my colleagues. I apologize for taking up so much time.
Justice Bernstein.
Counsel, good morning and welcome. And I have to say, I have so enjoyed listening to you make your arguments and have to address all these different questions. You've done an outstanding job, and it's a real pleasure and privilege to have you join us today. I just have a few questions that I just kind of want to walk through with you. And I was listening very closely to your responses to Justice Viviano, and you had made some comments and that I just want to touch upon a little bit about kind of the voter intent and kind of what the voters were thinking when they enacted it. And again, I have a few questions. I just want to start with a little bit of a broader question, and then we'll go a little bit more specific. Wouldn't you feel that the voter intent was to have a highly transparent structure in that they're changing the entire way that we kind of enact our system of government? So thus, they want to know exactly what's happening and how it's happening.
Absolutely. I absolutely think so. I think that the transparency that they sought, they obtained, but I do think the voters were looking for transparency. That's why there have been so many hearings. That's why everything without exception is posted on the internet. That's why they've been all around the state doing these hearings. But yes, absolutely.
So then let's move into kind of, again, one of the things that I always like to do is I like to look at things in a very common sense and sometimes more kind of simplistic approach. And the question I have for you here is, and I'd asked that to Brother Counsel, is let's look at the names of the two documents. And I just want to focus on those, if we could, for a moment, which is, basically the history of discrimination in Michigan and its influence on voting. That title kind of speaks quite a bit. And then the second one is, the Voting Rights Act. And I guess when you look at this from the intent of the voter in terms of wanting and wishing to have transparency, to the common understanding of the voter in the sense of wanting to know how these maps are drawn, when you look at the actual title of the memos that are in question, don't you feel that it kind of, if you're going to look at it, that it kind of leads to kind of the interpretation that the general person would look at that and say, wow, that must have to play a role in how these maps are created?
In answering your question, let me take this in two parts. First, a technical but important part, and that is the common understanding of the voter as to whether a particular document is an attorney-client document. There's no law that suggests that would drive an outcome. It's the common understanding of the voter, of course, in terms of what the constitutional provision should have said. And so that's about whether we do or don't have attorney-client privilege. I do want to speak directly, though, to the point that you've asked and that you asked Judge Zara, and that is the memo is entitled The History of Discrimination in the State of Michigan and Its Influence on Voting. And let me take a moment, because it's worthwhile, it's very important to talk about what we're really dealing with here. I'm not a national expert on the Voting Rights Act. I'm familiar with it and been involved in some litigation, but what is important to understand, and what Justice Bernstein, you probably do understand, is that litigation under the Voting Rights Act, under a Section 2 claim under the Voting Rights Act, starts with an initial analysis to determine whether the Gingle factors from the Thornburg versus Gingle case have been met. And if those factors are met, then we go to the totality of the circumstances analysis. And in doing the analysis, the totality of the circumstances, universally now, the federal courts go to the so-called Senate factors coming from the 1982 Senate Committee report that identified factors for consideration. Now, I know this is a little, we're getting in the weeds, but it's worthwhile. So if I can have just a moment.
Absolutely.
Thank you. The first Senate factor reads, the extent of any history of official discrimination in the state or political subdivision that touched the right of the members of the minority group to register, to vote, or otherwise to participate in the democratic process. Now, let's look back at the title. The title of the memo is The History of Discrimination in the State of Michigan and Its Influence on Voting. Stated another way, this memo takes historical facts, addresses those historical facts, and applies it to the legal question, which is the influence on voting. It's much like a memo if you're represented in you'll excuse me, an auto neg case. And the memo is entitled, the nature of the way you drove and whether you were negligent and caused an accident. Yes, it's about facts, but it's the lawyer's interpretation of those facts, or in a contract dispute, the nature of your relationship with the other party and whether you breached the contract. That's the law, and that's how lawyers do things. Now, I will say this, in this case, in the commission, there have been very, and it's in the record, in June and July, there were open sessions where the law was described and explained in excruciating detail, and facts have been presented about historical discrimination. There's a ton of that in the record. What you don't have is any memo where a lawyer applies the facts to the law, because that's attorney-client communication.
But so, counsel, and I appreciate your answer, and I thought it was excellent, but I think it kind of goes a little bit to the questions or the concerns that I have, which is ultimately, isn't this the kind of issue or kind of matter that basically, when you're basically creating districts that are going to go to our entire system of government, that ultimately needs to be left to the public to have this understanding and to have this appreciation of these discussions and how these decisions were formatted to such a degree that the entire reason that we're here is that it was only by a 2-vote margin that this material was not made public. So ultimately, I realize it's a majority vote, but the concern I have is that you still had you had a 2-vote margin as it pertains to whether or not the public should have access to these materials and to these conversations.
Thank you, Justice Bernstein. And I think you get right to the point, and that is, would it be good public policy to make these public? Would it be good public policy? Would it be a good thing and people would like to see it? Maybe, maybe not. That's a subject we can argue about. What we can't argue about is, is what does the amendment say? And to be clear, the amendment doesn't say anything that informs the understanding of the commission must be public. It says the data and supporting materials used to develop the plans. And again, these documents weren't available till after the plans were developed. And then it talks about other documents that can explain how the plan was created. If you parse, and I know you can do this, I know you will do this. If you parse the amendment, you will see that anything more open than data and supporting materials used to develop anything later than that date, I should say, is not so broad as to include something like this, these memos that we're talking about. So maybe it would be a good thing, but it had to be explicit. The Constitution had to say it explicitly, and it didn't. The Constitution did not say everything and anything's going to be public, including attorney-client communications. I'm not saying, I don't think that would have been good, but I can see why you or others might think it was good, but it wasn't done.
I understand. And I guess just a few more remaining questions. Doesn't that then go to the credibility of the entire Constitution if ultimately people have this doubt and this concern that a light is not being shined into these critical conversations that are being had when it affects the way that districts are being created?
Your Honor, we all know, and we've all heard, that democracy dies in darkness. And if in fact this was a dark process, I would not be here arguing it. What we have in this process is 136 public meetings, tens of thousands of literally the comments exceed 20,000 comments so far that have been public. Compare this to 10 years ago, and what did the public see? The Senate had 7 hearings and only 1 allowed public comment. So yes, openness is great, but no, I don't think anybody looks at this and says, oh, this is a secretive process. This is an incredibly open process with exactly 1 closed session.
No, and I appreciate that. And I only have 2 more questions for you. But again, this was a 75-minute meeting, which is lengthy. And as we all know who are in government and work in this area, you can have a number of open meetings, but everybody knows that the real business and the real things that happen in executive session. I mean, if you look at universities or any element of that nature, yeah, you can have a litany of open discussions and public meetings. But look, we all know that executive session is where things ultimately happen and where they take place. So I don't know if it's fair to say that just the duration or the quantity of a public meeting is outweighed by the brevity, quote unquote, of a 75-minute meeting that's in executive session, because a lot can happen in that fashion. The question I want to lead to you now is the issue of drafts and the issue of the various drafts. And I just want to make sure I understand the commission's position on this. Is it after the commission provides its first draft in terms of its first recommendation, if the commission has to go back and let's just say we have litigation and we've had this discussion, but I just want to be clear as to my understanding of the position. If the commission has to go back and then continually update and have new drafts being submitted as it pertains to kind of litigation or ongoing conversations or ongoing things that could or might be likely to happen, is it the commission's position that then those should be then confidential? That is it the commission's position, just make sure I understand it, that everything leading up to the first release, the first draft,
Oh, I hear you.
would be confidential, but then anything after that, if you're reassessing or redrafting, would remain confidential as it pertains to how this is done?
No, and I apologize. I don't mean to answer so abruptly.
No, please.
Absolutely not. No. This process was public, has been public, and will continue to be public. They did their map drafting right out in public, and now they're out for public comment. We're in the 45-day period right now, and absolutely, it's public. And if something changes, there are going to be a couple of public hearings that are scheduled in December, and it's going to occur in a public session. It's not going to be in darkness. It's not going to be quiet. The only thing I talked about that changed from previously till after that October 11th date, the only thing was the specific requirement that any data and supporting materials used to develop the plans are released. But the later step is, and section 15 provides that within 30 days after adopting a plan, they then have to publish all of these materials. It's very clearly defined. So no, it's still all public. We're not going to.
So anything going forward for the future, we don't change the standard from the first draft to the other drafts that will follow.
No, the standard doesn't change, but the right to have, our perspective, the right to have attorney-client closed session is under appropriate standards is still possible. But
Counselor, thank you so much, and it was really a pleasure having you with us today.
Thank you, Your Honor.
Justice Clement,
No questions. Thank you.
Justice Kavanaugh.
Okay, I can't resist. So I have sort of like a wonky practical sort of question. And ultimately it has to do with whether or not the plaintiff have asked us to have our court to have an in-camera review of these documents in order to determine, whether or not they exist. And I think Brother Counsel already indicated, sure, there is some attorney-client privilege with respect to litigation. And I think he made the representation that document number 3, they may no longer be contending is part of this litigation because that would be covered by the privilege, as Mr. Wilder describes it. Perhaps even number 2, relating to the lawsuits relating to census data in our court from earlier this year. So in looking at this question, I'm sort of putting it in the terms of like regular litigation, right? In the context of discovery, plaintiff files suit, asks defendant for all documents related to, I don't know, pick something, the termination of this employee, say, and defendant provides documents and usually provides a privilege log that then says, here's what's not being provided. It's responsive to your request, but it's subject to either attorney-client or work product privilege. And here's the description of it. The next step in that is for if plaintiff says, you know what, based on how you've described this document, I don't think it is subject to privilege. And I'm going to ask the court to take a look at it and make that decision of whether or not it's in fact privilege. So, but I think that the plaintiff has, what would plaintiff have to show to get actually into even the realm of in camera? Because the plaintiff's complaint, and I think even the Attorney General's opinion in this matter, we're talking just about the title of these documents, right? But if I look at your brief on page 26 to 27, where it provides the title of the document and an explanation of what this document is, and how it involves the asserted privileges. I sort of look at that as like your privilege log in some ways. Before we even have to say that we should look at these documents, what does plaintiff has to show to say, look, even given this description, some of this information is still is not in fact subject to attorney-client privilege. In court, you need to look at it and make that decision yourself. Do we have to do that based on sort of how what the information we have now? And I guess it's a really long-winded way of asking, like, do you think that we need to do an in-camera review of some or any or all of the documents?
Let me first just thank you for the question, and let me just say that the question showed a very good understanding of what's occurred here, and provided about half of what my answer would have been, because that's exactly right. What we created was intended to be a privilege log. That's how we described it in-house as we were preparing those pages, because we thought the court might want that to see, okay, what are these documents that they're talking about? But does this court have to do an in-camera review? I have to say it, there has to be some threshold before the 7 justices of the highest court in our state spend their time reading my memos. I mean, I'm flattered, but it's not necessary. What we're really dealing with is there needs to be some standard other than just a lot of curiosity. The Detroit News, the Detroit Free Press, they're curious about what our memos say, but there's no showing, there's no evidence, there's no reason to believe that anything improper has occurred. And this isn't a situation where they can't know what's going on. Everything has been open. We had, before the closed session was held, and by the way, the closed session, again, related to 2 documents, both of which occur after October 11th, or created after October 11th. So those are the only documents they really even try to make a significant case. The documents Justice Bernstein asked about, that they try to make a significant case that those documents should be seen as being part of the of our process of developing the plan. So that said, I don't know a hard and fast, clear answer, Justice. I will say this, that for this court to have to micromanage what the commission does on a day-to-day basis, which is exactly what they're asking for, just seems to be so outside the realm of practical experience or constitutional intent.
Are you asking, okay, and I don't mean to interrupt, but are you, so let's say document number 7, the history of discrimination in the state of Michigan and its influence on voting. Let's say we don't agree with your argument that because it's after October 11th, it's not a document that we're concerned with. Let's say we don't agree with that. So that document is in play for other reasons. If that document has 4 pages about historical facts regarding discrimination in Michigan, and then the last 3 are, based on these facts, here's my advice to you about what to do with this information. Could part of that, I mean, should the document be disclosed with the advice part redacted as being subject to privilege? But I mean, so I guess, are some of these documents, do we need to look at them and say, the advice is not subject to disclosure, but some information in those documents might be, some factual information might be.
Well, this gets down to the first question really that you asked, Justice Kavanaugh, and that is, when does the court read to see if the first 4 pages should be allowed and the second 3 should be redacted? When should the court do that? And the standard, as I understand it, is you have, and we do cite a case to this in our brief, situations where the party seeking the document can demonstrate the need for the materials and a lack of other reasonable avenues for obtaining it. Well, how badly do they need these materials? We were very open about what the law is. There have been public sessions about that, and they can find the law themselves. There's no mystery about what the Voting Rights Act says. There's a lot of case law. It's very interesting. It's complex. Nor is there any mystery about what the facts of discrimination have historically been in the state of Michigan. We see it every day. We read it every day. We know what it is. So when I say that, if this were something different, if this were, I don't even know what that would be, but they need to make a showing of why it's essential to them, why it's essential to the plaintiffs to have this information, and that they can't obtain it in another way.
And my final question, and I just want to, and I think the concern exists, it's not specific to the commission, but I think it is. I think it exists in regular litigation, right? There's a bit of a concern of, look at it's the commission saying, trust us. We're saying these documents have privileged information, and they say what they're doing. You know, they're saying, and any private party, I think, does that in respect to, you know, they're saying, we're producing all of our documents. Here's the documents that are subject to privilege. Take our word for it, right? I mean, so when you're talking about like some kind of burden that the plaintiff has to show of why even a court should look at these documents to do that, do they have to show that there's some reason to disbelieve the representation, or there's something in the statement of describing it that actually would suggest that maybe it's not advice or not interpretation or legal advice? So I guess, you know, I mean, there's the concern of like, you have one party who's saying, look, we're going to decide what documents are. And in this case, it'd be the commission saying, look, we're sort of, you know, we're deciding, trust us, this is privileged information. And like, what are they, I mean, do they need to show that there's reason not to believe them? And maybe if they were redacting every other document or holding a closed session in every public meeting or something, is that relevant to this idea of why do we even need to go to the step of looking at these documents to determine whether or not they're privileged?
I agree. I think those are some very good points. I think that there has to be something more than just curiosity, something more than just dissatisfaction, some showing of some reason that it's not true. For example, in this case, they know, and the record shows that these were documents prepared by counsel specifically retained by the commission to provide advice about the Voting Rights Act. Absolutely clear that's who it was who did it, and it, absolutely clear that that's what these memos were about. It's also clear that these memos are applying the facts to the law. There's nothing more basic than what a lawyer does than applying facts to the law. There's always going to be facts interwoven in those kinds of memos. It can even be the predominant part of the memo. But in the end, there's a legal opinion that's provided to the client, or legal guidance that's provided to the client. And so, but the second point made by the court, I think is by Justice Kavanaugh, is a really very valid point. I think you need to look to the totality of the activities of the commission. Yes, if the commission was conducting 7 closed sessions a week and 1 open session, it would start to get curious. If every time a lawyer stepped in the room, they said, "Okay, it's attorney-client, shut it down." Justice Bernstein talked about it, the unfortunate possibility that all of the decisions are made in an executive session. We don't provide facts or anything like that, because the facts that we have are 1 session out of 136. In a session that occurred after the first round of maps had been released. So I don't know what that showing has to be, but I think it's got to be more than just we really care, so we'd like to see them. I wish I could give you a bright line. I wish there was a bright line, because in the absence of a bright line, the analogy provided is a very good analogy. If you're in litigation, two parties in litigation in the circuit court on a case, and it's been going on for a long time, and one party produces documents and there's a privilege log, it's very common for the court then to say, okay, well, I'll look at those, or I have a special master look at those in camera. But to think that under our Constitution, the Supreme Court, which has original jurisdiction for this case, is now going to have to review itself every single memo that any one of the lawyers sends to the commission. Wow. So I don't think that's realistic.
Okay, thank you very much.
Justice Welch?
Thank you. Justice Kavanaugh covered a lot of my questions, so thank you, Justice Kavanaugh. So, Mr. Fink, I've sort of struggled with the same, what is the line? You know, having sat on a publicly elected board, I am well aware of how the closed sessions worked and what we could and couldn't talk about, and we took that extremely seriously. You gave the example of, you know, if there were 7 meetings, there's some threshold crossed where they're always claiming attorney-client privilege. So if whatever that line is, I understand it's your position that doesn't apply now. What then would the public's avenue be? Would it be at that point, we then look at all the documents that are explored in those meetings? What are your thoughts on that?
I could envision a process, a context in which there's some indication that the attorney-client privilege is being abused, that in that context, the justices might review the memos. I guess in a worst case scenario, they might even listen to the hearing, which, you know, the recorded hearing. But it seems to me that in the context we are in right now, there are no special factors. I wish I could tell the court what the special factors should be. There's got to be some kind of special factor other than just we had a closed session, because that would literally mean every closed session should be recorded and sent directly to the Supreme Court. And how can that possibly be the way that a public commission operates? But I don't know the right answer.
Okay. Final question, and I asked this of Mr. Wilder too. We know the Constitution uses this language, the amendment uses this language about legal representation. I am sort of interested in the notion that that was the language used, and it wasn't even just attorney. And just an attorney in this concept, in this context, could just be a subject matter expert, basically. And I'm wondering if you have thoughts on that specific terminology that was used.
I do, because it's not just that language. First of all, that language absolutely, including legal representation, is more than just retention of counsel. But more importantly and more clearly, in in Section 6, subsection 6, it provides that the legislature shall provide adequate funding to allow the commission to defend any action regarding an adopted plan. So that is, it couldn't be more clear that they intend to provide that support. But legal representation must be more than just defending the plan. If it weren't more than just defending the plan, that's what it would say. It would just say defending the plan. So it is legal representation, and that's every form of legal representation. I can't imagine, because they know how to be specific, and they were specific in another part of the amendment. Now, there's other references, as the court knows, to retention of legal counsel. And again, it's very, very clear going into this. Yes, they knew there'd be litigation. Yes, they knew they'd have to be careful about everything they did, every step they took, and they've been careful. And yes, they knew they had to know what the legal consequences were of the things that they did.
Thank you.
Mr. Fink, it seems like you all agree about a lot. I think you agree that there that there is more transparency required by this amendment than perhaps ever in this process before. I think you agree that The attorney-client privilege applies to at least some part of this relationship. You might disagree about where the lines around that begin and end. And it seems like you probably both agree that you want us to say something about how this works going forward. I assume you don't want us to just, I don't know if we can deny leave in an original action, but whatever, dismiss the petition. Do you want us to say something today or as a result of today?
Let me do a little math first. I think no, the answer is we faced that question before we filed our response. And we said right in our response, before I had the privilege of hearing the perspectives of the justices, we said right in our response that we would like some guidance, because the situation that we're in right now is we are hamstrung. And I mean, I guess I used that word earlier, but I assure you, I'm not going to go into closed session and say a word to the commission until I know whether I can without it being public. I've had a public, many years ago, I had a closed session of the Detroit City Council published in the Detroit News. Because a Court of Appeals said it could be published. Fortunately, I gave the right advice. But in this context, we are feeling, and this is why we feel it's so urgent, we don't know how to advise the client. We don't know how to tell them about litigation risk. We know how to tell them how to defend a case once it's filed, I hope, although until today we hadn't heard the clear admission that it would be okay to talk about litigation. But the fact is, we don't know how to advise the client. So yes, we do want guidance. That's why we didn't object to their standing, because I think there could have been some questions. We didn't object to a lot of issues, because our feeling was you were the 7 folks we wanted to hear from.
So that's what I thought, because it seemed to me that probably you need some guidance on where the lines are around the confidential advice you can give your client and the promise of confidentiality you can give to your client. So I assumed you wanted something from us, and it feels to me like there's a lot of agreement about at least some parts of where that that privilege begins and ends. There are obviously all kinds of examples in the law where trial judges, which is what I guess we're acting as, 7 trial judges in these questions, have to balance the privilege or the work product exception against some disclosure requirement, whether it's in a statute or a court rule or some other legal requirement of disclosure. And courts do that all the time, and in a way, balancing those two here is just another example of that, except when the disclosure requirement is, by your own admission, sort of supersized by the Constitution. The way the Constitution really wants this work to be done publicly, and as Justice Bernstein raises, the titles of these 2 documents might give the public some pause about whether these are the 2 kinds of, these particular 2 documents are ones that this court, like any trial court, should sort out. I hear you, I hear you, believe me, about us, 7 of us, reviewing every single thing that ever happens between you and your client. But why isn't it the case that because of the titles of these 2 and their relationship, those titles at least, we don't know what's in them, their relationship to the work, the business the commission is under, shouldn't we look at these 2 to figure out which side of the line they fall on?
Well, I appreciate, Chief Justice, the analogy to a trial court. In a trial court, if you want to challenge the assertion of a work product, of something that is based on the privilege log, if you'll call it that, is clearly a type of work product, because there's no question that this is addressing the history of discrimination and its impact on voting. That's the title, or essentially so in a trial court setting, to get past work product, the plaintiff has the burden of showing to the court that there's some insurmountable barrier to getting that information. We're talking about history, and history, this is history that's available to the public. There's no reason that there's a special factor. Now, if this were the the sworn statement of the decedent, the sworn statement of somebody no longer available to be spoken to or interviewed. Yes, that's where work product gets set aside when you've got a situation where there's no way to duplicate it. In this case, it is 100% duplicable, if that's the proper word, because they're not entitled to, it's none of their business what my opinion is or what Bruce Adelson's opinion is of the law. So that part they've got no right to. The only part they'd have a right to would be any facts that are there, but there's no showing that those facts, that there's any reason to think that those facts are facts that aren't available to the public from publicly available sources.
Okay. Let me see if anybody has any follow-up questions based on, we've used up way more than your time. Are there any additional questions for Mr. Fink? All right. Well, thank you very much. I'm going to see, Mr. Wilder, let me just see if there are any follow-up questions for you based on all of the questioning we just did of Mr. Fink. So if you don't mind, are there any additional questions for Mr. Wilder? Justice Zara.
Okay. Just briefly, if you could respond, I'm thinking about the proposition I laid out to Mr. Fink about if the document is used in the get the exact language. If the document is used to support the materials to develop the plan, and Mr. Fink pointed out, well, the two documents at issue were created after the plan, but Article 9 refers to proposed redistricting plans, and then there's a period before we have an adopted plan. What must be produced in that interim period between a proposed plan and an adopted plan?
I did it to myself. I was muted. I'd like to point out that at page 3 of the commission's brief, they mentioned that after the October 11th date, there was significant public feedback on the draft proposed maps. It then held 9 public meetings between October 27 and November 8 to review and discuss the feedback, engaged with its experts, and then made substantive revisions to the draft proposed maps, and then voted to publish proposed maps. And it simply belies credibility to think that those memos did not inform that additional feedback and redrafting of the maps before republished. So again, when you look at the titles of these memos, with perhaps the exception of 2 and 3, as Justice Kavanaugh pointed out, it is clear that these memos are going to the heart of the commission's work in subsection 13, the criteria they must meet in order to do their business. And that's why it's not a curiosity. It's because the Constitution demands that the business be in the open. And so if they've used that for purposes of their business, it should be disclosed to the public.
Thank you.
Justice Bernstein, you had a question, I think?
I did, just one quick question. And Counsel, if you could just comment, because this is the thing that I have concern about, is that it goes to presumption and default. And my concern, Counsel, is in addressing those two concepts is that the idea here is that it appears that the commission is arguing is that, you know, you have to show more than a general curiosity in order to be furnished with the information that the public or media feels is relevant. And I guess the question is that if the presumption then is you have to show more than a curiosity, first off, my question, well, I'm going to ask you two questions is that I would hope that in something that affects our overall system of government, that everybody would have natural curiosity. I mean, basically, this is the entire system of government for our state and, in fact, the nation. And so it would be my hope that all people would have a natural curiosity for the ongoing issues and decisions that are being raised. But the question is that going back to the titles of these specific memorandum, my concern is that, am I understanding the commission's position correct? And if you could just elaborate on it, is that ultimately, when you have titles such as this that are being that are being determined to be attorney-client privilege by the commission, that ultimately that the presumption is going to be that documents, memoranda, conversations can in many ways fall under the guise of attorney-client privilege, not being released to the public, and thus you would have to have more than a general curiosity as to what the information is and how that information is being relevant to drawing the districts that we're all going to have to live under.
I would say, Justice Bernstein, that I would fall back again to the language of the Constitution. If it relates to doing the business of the commission, and that means that it is a supporting material in drafting and proposing the maps, it should be released to the public. And that's why we've asked for the court to order that they be released. The titles clearly show they were something that were supportive of the map drafting process and were utilized by the commission in ultimately revising and proposing the maps that were ultimately republished.
Counsel, thank you very much. I have no further questions.
Thank you.
Any additional questions for Mr. Wilder? Thank you both. The case will be submitted. We appreciate your time.
Thank you.
Thank you. And we would like to thank the court for taking this on such an expedited basis. We appreciate your patience during our long argument.
Thank you.